Good day, Crime Talk aficionados. It's Sunday, which means it is time for the weekly recap of all the top stories that we talked about throughout the week, beginning on February 24th. We hope you enjoy the recap of all the top stories throughout the week, conveniently located in one location. It's a weekly recap, ladies and gentlemen. So don't tell me in the comments, did I see this already? It's a recap, but it's worth watching. Have a wonderful day. We'll see you next time on Crime Talk.
All right, lawyer.
The Bryan Kohberger matter. That's right. The judge in the Bryan Kohberger matter has unsealed 175 pages, partially redacted. Now, let's just say I'm going to go through this with a fine-tooth comb tonight so that you don't have to. But I can tell you so far, what I've looked at, it's a nothing burger. And it makes the state of Idaho look ridiculous that they think that we, as citizens of the United States, can't handle what's going on in the proceedings. Okay? Nowhere in 30 years of criminal law practice have I ever had a proceeding closed to the public, held in secret, other than maybe for a juvenile matter. I am serious. Idaho, you look ridiculous. Let the people know. There was nothing in here that was going to taint any potential juror. Have we not found from, particularly in Idaho, the Lori Vallow and the Child Day Bell matter, that there were people that hadn't even heard of this particular case, but yet everybody acts like everybody's reading the newspaper and looking at all the information on this particular case. Just because somebody knows about a case doesn't disqualify them from jury service. The question is whether they can put that aside, make their decision based upon what is presented in court. That is it. But yet Idaho has this ridiculousness about everything. And guess what? Judge Hippler looked at this and said, I'm releasing to this public because the public has the right to know. All right, let's take a look at the order that the judge signed. It's pretty clear. Matter becomes before the court. The state's motion to seal proposed redactions. The state has identified 4 categories of redactions that it asserts are appropriate under Idaho Code of Administrative Rules 32. References to the names of witnesses and roommates of the victims. Inquiries by defendant related to the Franks motion, which the state objected to and was sustained. Names of defendant's instant relatives identified through the IGG. And number 4, individuals who are identified as potential relatives of the defendant through the Ortham Laboratories IGG. The court finds that the redactions are appropriate as to categories 1, 3, and 4. And that the individuals' names are exempt from public disclosure under the rules, as public releases would constitute an unwarranted invasion of a person's privacy as defined in Idaho Code Section 74-101, paragraph 16, subparagraph A, subparagraph II. In addition, these redactions are warranted under ICAR 32, given the individual's privacy interests predominate over the public's interest in disclosure. Publication of the identities could be highly objectionable to a reasonable person, could endanger their lives and or safety, and could jeopardize the right to a fair trial in this matter. Really? Redactions of their names is the least restrictive measure consistent with privacy interests at issue, with preserving the integrity of the case and the right to a fair trial. Consequently, the court orders that categories 1, 3, and 4 be redacted from the January 23rd, 2025 closed hearing transcript. So we don't get the names and witnesses of the roommates of the victims. We already know that. It's already public information. Whatever. Paragraph 3, names of defendants' distant relatives identified through the IGG. Really? 4 individuals who are identified as potential relatives of the defendant. Really? Like I couldn't go on to genealogy.com and find that out? What a waste. What a waste. And really, we don't know. Anyway, we move on. Anyway, the transcript of the closed hearing in which the University of Idaho murder suspect Bryan Kohberger defense team sought to undermine the credibility of investigative genetic genealogy research that helped police obviously focus on Mr. Kohberger in connection to that quadruple homicide. Now, the judge has previously told both the prosecution and the defense to propose redactions before he released the transcript. Ms. Taylor, Bryan Kohberger's attorney, tried to portray the investigative genetic genealogy evidence, or IgG, as improperly left out of the probable cause affidavit used to justify several warrants in this case, including the search of his property and his arrest. But the Moscow police detective Brett Payne, the lead investigator, testified that the IgG lead was merely a tip and said authorities dug up more evidence that they allegedly linked Bryan Kohberger to the case. Quote, "We made the decision in an effort to independently verify the information that we provided to us as a tip from the FBI in much the same way we would any other tip in law enforcement. So it was not in any way meant to obfuscate any sort of information. It was simply, can we validate Mr. Kohberger's involvement in this incident or can we not? That was it." End quote. Anyway, the redacted information includes the identity of the surviving housemates who's witnessed a man with bushy eyebrows leaving after they heard sounds of a struggle, as well as the names of the 4 brothers who were identified as potential relatives of Kohberger during the IgG process. The identities of the brothers and other distant relatives are subject to prior protective orders in this case. Now, Matt Garnett, director of the Idaho State Police Forensic Services Crime Lab, testified that the Othram's urging, an ISP detective reached out to one of those brothers and asked him to submit his DNA to a database that law enforcement would allow to search. Now, the unidentified man at first doubted the detective's identity and later declined to cooperate, telling police not to contact him again. And then by December 10th of 2022, the FBI ultimately got involved. 9 days later, they shared Kohberger's name with Detective Payne. Now, defense expert Dr. Larkin, a genetic genealogist, testified based on her review of the discovery. She believes that someone at the FBI violated internal policy at the terms of service of one or more of the genealogy databases to come up with the lead that led to Bryan Kohberger. We talked about this. The court said, it's a policy. It's not a rule. It's not a law. It's not going to get anything suppressed. Anyway, it was testified that she believed that they asked them to turn over the match list, and they were like, we can't turn over the whole list because it was 20,000 people, it was testified to. And that actually, there was a big tip-off, because if they had only used GED Match Pro and only used Family Tree DNA, then they could have gotten no more than about 10,000. So right there, that tipped her off that the government, were in the database that they should not have been in. Now, through further discovery, it was determined that the FBI admitted to using the MyHeritage and GED Match without the Pro database. Law enforcement isn't supposed to actually go in and search, but they did. It's a general policy. The FBI has not commented, other than saying, go look at Judge Hippler's February 17th order, which found investigators had not violated Mr. Kohberger's constitutional rights with the IgG search. And as noted, Judge Hippler ultimately rejected the defense motion to have the IgG evidence tossed, which basically, where the court said the FBI had not violated Kohberger's rights because he had no expectation of privacy, and it certainly was not one that the public was going to recognize. We brought you all those orders last week, and so that's all the defense was really hanging their hat on, is that you shouldn't have been able to go in, get this IgG information, because had you not been able to get it, you would never have arrested Bryan Kohberger, and you wouldn't have been able to get all the other search warrants that they tried to suppress. Remember, you file a motion to suppress when it is devastating to your client. You want to get it thrown out, and that's what they tried to do. So all those searches, the emails, the Amazon delivery, the orders, things like that, that's what they were trying to get thrown out based upon saying there was a violation of his rights through the IgG. Court rejected that argument, didn't think that was going to fly anyway. During a 2-day public proceeding that followed the closed hearing last month, the defense argued that the FBI violated Kohberger's rights under the Fourth Amendment as it related to unreasonable searches and seizures. Well, like I said, the court rejected that argument. Now, the police, or what we do know is under Mogen's body, police found a knife sheath that helped crack the case, because apparently on this little button right here, on this little K-bar, that's right, there's DNA sample. Anyway, the Idaho State Police and the Othram Laboratories failed to generate leads from the sample. However, according to the transcript, the FBI then stepped in with their own resources and provided this tip that, hey, go look at this Bryan Kohberger guy. 11 days later, police arrested Mr. Kohberger at his parents' home in Pennsylvania. And on multiple occasions, Ms. Taylor attempted to question witnesses about other topics outside the IGG, but Judge Hippler sustained objections from prosecutors who noted that the hearing was solely dedicated to the IGG issue. Anyway, Bryan Kohberger obviously has entered pleas of not guilty. We'll give him the presumption of innocence, and his trial is scheduled to begin in August, and it's expected to last for at least 6 weeks. Now, obviously, if he is convicted, he will get the death penalty if a jury were to find that he was worthy of it. It's just an option. But also, it looks like Bryan Kohberger has yet another attorney. The court granted a motion for a pro hoc vice admission, finding that Bicca Barlow be admitted pro hoc vice in this case, and that Ann Taylor will serve as the local counsel and should be required at all court proceedings in which Miss Bicca Barlow appears, unless specifically excused from the court. Further ordered that co-counsel Elsa Mathis will remain in her position as trial counsel. Co-counsel Jay Loxon will remain as consulting counsel, but will not participate as trial counsel. So there you go. Luigi Manjoni, he says no more. That's right. Luigi Manjoni, the man accused of assassinating the United Healthcare CEO, Bryan Thompson, has delivered a request warning to his fan base about how the police are screening his communications. Can you believe that, ladies and gentlemen? People are actually sending stuff to Luigi Manjoni with the expectation that somebody at the jail is not going to read it. Are you kidding me? Of course they read everything that goes in and out of the jail, unless it is marked attorney-client communications. Anyway, Manjoni, like I said, the accused killer, is reportedly being flooded with fan mail at his Brooklyn Federal Detention Center, where he is currently residing. And he is asking his admirers to stop. No more photos, ladies and gentlemen. Apparently, the volume of photos has become so overwhelming that he's begging his followers to limit their submissions to just 5 photos at a time. And remember, they are being screened, ladies and gentlemen, so make sure they are appropriate for jail, if you know what I mean, right? Now, Mr. Manjoni appreciates the photos that have been sent and kindly asks that people send no more than that 5. Anyway, the update is a reminder to his admirers to please note that every photo that is received is screened by law enforcement, i.e., stop sending the X-rated stuff. Anyway, Manjoni has also collected more than $615,000 for his defense fund as of today. And obviously, Manjoni has attracted a substantial fan base, mostly female supporters. And apparently they packed the New York courthouse where he appeared last Friday, desperate for a glimpse of the accused murderer. Fans waited in the corridor of the state course, and a truck circled the building with a large picture of Manjoni dressed as a saint. Even had a halo in it. That's right. Saint Luigi. Anyway, court officials estimated that between 250 and 300 people attended that hearing. So no mas, ladies and gentlemen. No mas. No more photos. But at least make them G-rated, all right? Otherwise, he's not going to get them. Next on the docket, Karen Reed had another hearing, nothing got accomplished, and boy, did it kind of spiral out of control. So the judge in the Karen Reed case abruptly ended a motions hearing last week, February 18th, telling the attorneys that she had just been provided information that caused her grave concern. Not just concern, but grave concern. And anyway, so she had a hearing that was yesterday, and we brought it to you live. If you want to check out that hearing, you can. I'm telling you, though, the defense droned on and on and on for about 4 hours. The prosecution did their statement in about 30 to 45 minutes. And I think what you can glean from the defense was, thou protest too much. Okay. Anyway, the judge explained her reasoning, saying that she was alarmed to hear that a previously undisclosed relationship between Reed's attorney and expert witnesses in her first trial that wasn't properly disclosed. So at the first trial, Reed's defense team had 2 accident reconstruction experts initially hired by federal investigators, and they testified on Miss Reed's behalf. Now, midway through the trial, Reed's defense, led by Alan Jackson and David Yannetti, told the judge that they had no contact with experts before their testimony. But on February 18th, the special prosecutor, Hank Brennan, revealed documents that showed several messages between Jackson and the experts about what they would and would not testify to, as well as an invoice for $23,000, which was ultimately paid by the defense. Well, Robert Alessi, he was another attorney brought in to basically handle this issue. And I said, if you go back and look at my video last week when all this went down, I said, "Ooh, yeah, Jackson better get himself an attorney. He should not be doing any talking." All right. So anyway, this Robert Alessi guy gets up and he drones on. And he got up there and represented the team as a whole in addressing the issues at the hearing yesterday. Now, according to Alessi's account, the sole contact with the expert was through Jackson and was limited to simply coordinating testimony. Coordinating testimony, they were talking about what should and shouldn't be asked. And anyway, Mr. Alessi said, "This is one of the most unusual situations I've seen in my practice of law. You have these experts, you have great exculpatory information, but there's significant restraints in how you can use the information. And that issue with the expert witnesses in this case," Alessi explained, "was that they had been hired by the United States Attorney's Office because the feds were doing their own investigation, but they had contributed reports that were exculpatory to the defense." Alessi emphasized that regardless of any communication between Reed's team and the witnesses, the reports were written well before the trial and no information within them was ever changed. Now, when it comes to explaining the $23,000 invoice that was paid, Mr. Alessi said the defense team was a bit shocked that they had actually received a bill. It came out of the blue. It gets sent to Mr. Jackson's office apparently in July. Now, he said he couldn't go into attorney-client communications, but there was one person that was more shocked than most about the invoice coming in and the amount. Now, Mr. Alessi emphasized that the invoice was dated July 12th, which was 1 month after Reed's first trial ended in a mistrial. Now, Alessi did confirm that Reed paid the invoice after Jackson consulted with the United States Attorney's Office to confirm that paying the experts was legal and appropriate. That was news to Mr. Brennan, who said, "It wasn't until Your Honor asked today that we even knew that the defense paid this bill." Anyway, after Mr. Alessi did his presentation, which, like I said, goes on for 4 hours, the judge addressed Mr. Yannetti and Jackson basically personally, and attorney Elizabeth Little as well, in turn to ask whether they disputed. And they each indicated that Alessi's versions of fact was correct. Now, Mr. Brennan, the special prosecutor, fired back at Alessi's claim that the defense has repeatedly violated the court's rules, calling minor violations a raindrop in a hurricane, and emphasized that his intention is not to preclude the experts from testifying, but rather to get the discovery evidence to which he is legally entitled. So Brennan characterized the defense relationship with the United States Attorney's Office as murky and said there were enormous gaps in time between emails that suggest there is an unclear history of interaction between the defense and those expert witnesses. Well, the judge, as normal, adjourned at 4 p.m. and said that the parties would reconvene the hearing next Tuesday on March 4th, and will decide where they go from there if necessary. A couple of things I think came through from this. One was there was definitely contact by the defense. The defense's argument was, well, there's contact, but it doesn't really matter because they were going to testify to the same thing anyway. The point is they made material misrepresentations to the court, and at some point, Mr. Jackson is asked by the court, did you pay them for their testimony? This was at a sidebar at the hearing on the 18th. And apparently Mr. Jackson said, I did not pay them for their testimony. I paid them for their time. Well, I think you have a duty of candor to the court. If they were some third-party witness that was testifying for the good of the cause, so to speak, and to make sure the truth got out, I wouldn't be paying a $24,000 bill. I assure you of that. Unless, of course, they thought they were going to get paid. Well, the drama continues in the Karen Reed case, as it always does. And like I said last night, we've got the Karen Reed camp that obviously thinks that she can do no wrong. And then the camp that says Karen Reed is so guilty. How could anybody believe that she didn't hit her former boyfriend, Mr. O'Keefe? Anyway, the bottom line is I get complaints from both sides. So I guess I must be calling it fairly. All right. I have said in the first trial that I watched that I would have found her not guilty in the first trial. But I also have said that I think the wheels are starting to come off on the Karen Reed defense team's case. And I think because the defense normally doesn't do better the second time around, that, like I said, the wheels are starting to come off. So we'll see. Let me have it. Let me have it. Bring it on, the Karen Reed camps. Guilty camp, totally innocent camp.
Next on the docket, Donna Adelson. Remember her? The alleged mastermind in the murder for hire of her former son-in-law, former FSU law professor Dan Markle, who was shot and killed in his driveway. Well, her son, Charlie, has already been convicted for his role in the plot, and along with Charlie's ex-girlfriend, Catherine Magbuana, and along with two other men. Anyway, Donna was obviously arrested and is in custody, and she was just about ready to get away to Vietnam, where they didn't have an extradition treaty to bring her back. But as she remains in custody, well, she would like to get out of custody. So there was a hearing that was held to see whether she should be given a bond of some type, because while she's been in custody, she has been assaulted several times and she doesn't like it and she would like to go home. Anyway, like I said, she alleged, as she testified in the stand, that she was assaulted multiple times, first time being in the shower. Apparently, all of a sudden, she felt a hand go up her back from the top of her butt. And she apparently started to cry. And when she screamed, the inmate ran away. On another occasion, another lady said, unless you want your pretty white teeth knocked out, you're going to buy me some commissary. Ms. Adelson would not name the woman other than describing her as a big woman. Anyway, Ms. Adelson also described a bunch of medical issues that she is facing, including sciatica, earwax buildup. Yep. Earwax buildup and sciatica. Okay. Motion for bond reduction denied. You are a flight risk, Miss Adelson. You're not going anywhere. The only way you're going to go anywhere is if you are found not guilty. Anyway, the judge reserved ruling, but I'm telling you right now, denied. Jail is a dangerous place, ladies and gentlemen. There's lots of people in there that don't like to follow the rules. There's a lot of people in there that kind of goes back to old, kind of the survival of the fittest, strongest rules, so to speak. Maybe not the world Miss Adelson is used to, but she better get used to it. She's a flight risk and a danger to the community. She is not going anywhere.
Next, Rex Heuermann. Guess what? He wants that pesky DNA to go away. Boy, does that sound familiar? I know some people say, oh, it's just DNA. But unless it's in your house, where you'd expect to find your DNA, if your DNA is at a crime scene, sometimes you got some explaining to do. Trust me, I have tried these cases, ladies and gentlemen. I'm not trying to sound braggadocious. I'm not trying to say I've done it all. I haven't. But let's be realistic. If there is a bad piece of evidence in your defense case, you need to sit there and think, how do I make this go away? Well, the Rex Heuermann case, the bad piece of evidence is the DNA evidence. So what are they trying to do? Say, Judge, you can't trust this lab. They're not accredited in the state of New York. Keep it all out. Nice try, but I don't think that argument is going to fly. So Rex Heuermann was back in court. His defense team pled with the judge not to accept DNA findings as evidence, and prosecutors said those findings will show that Mr. Heuermann killed 7 women. It's that simple, according to the prosecution. We, of course, will give him the presumption of innocence. Anyway, DNA is at the core of the prosecution's case against the alleged killer, Mr. Heuermann, but defense attorneys claim the science, nuclear DNA, has never been used before in New York court at all. And Heuermann, who was there in court along with his attorney, Mr. Michael Brown, claimed that prosecutors were hanging their case on forensics found on the strand of hair from each of the 7 victims. Now, the California lab that performed these tests, he argued, is not certified in New York, and therefore the whole case must be thrown out. Anyway, the district attorney defended the use of the evidence and noted that the science has been around for many years. And they said this is the first time we're taking a sound science and applying it to the criminal coverage area. It is the field of DNA analysis accepted both in New York State and the country, the prosecutors noted. Anyway, the judge granted the defense another 2 weeks to receive some more DNA evidence that is caught up in apparently some sort of lengthy download situation. Anyway, the defense says they call it science. We're disputing that, and we're looking forward to getting things that we're entitled to. We're still waiting for a significant portion of discovery that they're entitled to, and then they'll be ready to proceed forward, the defense noted to the court. Mr. Heuermann has pled not guilty to first and second degree murder in the killings along the Gilgo Beach of Melissa Bartholomew, Amber Lynn Costello, Megan Waterman, Maureen Brainerd Barnes, Jessica Taylor, Valerie Mack, and Sandra Costia. In another argument in court, the defense called for separate trials, contending that the one trial influences the jury when so many allegations are lumped together. The defense is saying, hey, these cases have nothing to do with each other in the sense of other than the sense of location where the bodies were found, type of murder that was committed, and the evidence that they have. They have no business trying some of these in court being tried at the same time, the defense is arguing. Now, the prosecution said that it's a serial killer case and that they all belong together at one trial. The prosecution said, hey, this guy's a serial killer who methodically hunted and murdered 7 women. That is our case. A lot of the evidence of one charge should be admissible in court as evidence of the same charge. Now, after a year and a half, the judge in this case appears to be running out of patience and is somewhat eager to move the cases to trial. He has now ordered everyone back in court on March 12th for further consideration as to whether the DNA evidence from California should be admissible at trial. These cases need to be moved along. Obviously, I'm not a big fan of 404B evidence, but this is the kind of case where 404B evidence probably comes in. It shows a pattern that takes place. And if you can link all of them together, even if they're not all tried together, then you bring them in as 404B evidence to show, hey, judge, this is our guy. This is the similar conduct that took place in each and every one, i.e. sex workers killed, buried along the beach. Oh, and by the way, we just happen to have some DNA evidence from Mr. Heuermann on all of them. Kind of shows kind of an absence of mistake, modus operandi. I think that will come in. And I get the judge's frustration. I get it. 7 homicide cases. It's not going to drag on forever, but you got to give everybody a fair chance to take a look at it, challenge the DNA evidence, and move on. Let's face it, DNA evidence is not new. It is generally and widely accepted. You don't need to have a Daubert hearing to go into that anymore. And certainly, if there are challenges to this DNA evidence, it can be brought up on cross-examination. It doesn't mean that all the DNA evidence is not coming in.